Clearly there were some wrongdoings going on or improper actions, or at least the fear of that by some parties, because there was a maintenance settlement agreement, which I'll refer to as an NSA, reached by the parties. And quoted here was that the association was to hire a management company, and this is the quote, to manage affairs of the association, excuse me, including but not limited to building and grounds maintenance. And see, I think the goals of the MSA were make things transparent, bring an objective third party or an intermediary in, being the management company, who can be involved in maintenance, which is the biggest issue you all face in Bigtree. Prevent favoritism. You know, the buildings are getting fixed because the board president is having his building fixed. I don't think the goal of it was zero involvement from the board whatsoever in maintenance. That's just not realistic, particularly forever, in perpetuity. One of the board members, a few of the board members raised the concern, if the board's involved in maintenance, are we violating that MSA provision? I think you can make an argument you are, just because it was worded so vaguely. Again, the term manage is pretty broad. I don't at all think that means the board can't be involved. Boards have to be involved in the community's maintenance. There's no other way to do it as well. So what we've discussed in terms of future plans, number one, we have to comply with the MSA. I mean, that's unquestionable. That's black and white. If we violate the MSA, it is a court. It's not a court order, but it's authorized by the court. It's enforceable through the court. So if the Bigtree Association is found to be violating the MSA, that could bring liability. So the solution there is to come up with formalized procedures for handling maintenance that most importantly are documented. And the procedure that was, I believe, drafted by Mr. Jasper was really well thought out and really comprehensive. Maybe that is the procedure. Maybe it's that, or a slightly different flavor of that. And that was a heck of a start. Once we've got that documented, and everybody's on board with that, and we've got a management company filling in the role that we believe complies with that mandate to have them managing the affairs of the association, you all have to operate under those with confidence moving forward. You can't fear the threat of continued litigation. You can't stop people from filing lawsuits. Everyone has the right to do that. However, if you believe, if we have the right procedures in place and we vetted them correctly and we're implementing them correctly, we'll prevail in court if we're sued in the future by homeowners.
How much more costly will it be to take on these other duties for a property management company?
You know, we haven't got there yet. I think if we create the right procedures, and I don't want to speak for Bob, but if we create the right procedures that both, one, accomplish our goals, but are also workable and realistic and feasible for the management company, perhaps there'll be no increase in cost. I want to talk a little bit about the liability aspect of this, because that was really what raised this to the forefront and led to a lot of the directors resigning. Liability, by its very nature, requires improper conduct. Whether you're talking liability to a personal director like Larry, or whether you're talking about it to the corporate entity, the Bigtree Association, Inc., there has to be improper conduct there, or at least negligence on the association side. In terms of personal liability to a director, there's very strong protection in the state of Florida, in fact everywhere, which is referred to as the corporate veil. It's very hard for you to get sued as an individual. Well, take that back, anyone can sue anyone. It's hard for you to get hit with a claim of liability personally when you serve as a director on a corporation. In order for that to happen, you have to have willful misconduct or malfeasance. They're the kind of things you lay up at night and you know you did something wrong. The idea that if one of you were to volunteer to serve on the board tomorrow, you could be hit with personal liability, some sort of money judgment against you, or have your credit hurt, I think it's purely erroneous. I think it would take additional future improper conduct for that to ever be done. The hypothetical that led to that wasn't erroneous, however. If we didn't create these formalized procedures, if the board just continues to be the sole party in charge of doing maintenance, and the MSA provision says a management company is to be the manager of maintenance, then could that be intentional misconduct? It potentially could, and so that's how we got here. While it was a valid concern, and that's what started this whole thing in November, I mean, it came to my desk as, is there any way this could ever lead to liability? That was the question presented to me that got my involvement in this whole matter. While there was a valid discussion we needed to have, I think the idea that the exposure was imminent was false. I don't think the exposure was imminent. There could be exposure down the road if we don't conduct ourselves properly, but it wasn't imminent. Having said that, you can't prevent somebody from suing you, and that in itself may not be worth it to it. So my point is that the initial discussion that started in November of can we come up with a hypothetical where a director is held liable? Putting my lawyer hat on, we were able to connect enough dots that said, you know what, if we don't create procedures, we don't get the CAM team involved with maintenance, the board does it on their own, does that potentially violate that clause from the MSA? Could you deem that willful misconduct? and therefore be personal liability. Sure, ... I didn't want to imply that any board member that resigned did something wrong. Number one, I respect anybody's right to resign for whatever reason. It's a volunteer position and it's a difficult one. So whenever somebody wants to resign, that's not a negative jab towards them at all. And particularly in the climate that had been created since November, I don't blame directors who chose to resign. So I meant to point that out earlier. I didn't want to vilify directors who had resigned. So what does this look like? What are the next steps in this process? Well, first of all, you need to fill your board. As Lisa pointed out, you don't have a quorum. Without a quorum, you can't take action. In fact, you could potentially have someone, go to a court of law and ask for a receivership to take over your community, which is not a road you want to go down. It's very costly. You give up control of your community. You don't want to do that. So at the very least, you need one more director. It would be great to get back to 7 directors. Under your bylaws and under Florida statute, whenever there's a vacancy, which you now have 5, the remaining board members have the right to appoint directors. So the board, in the very near future, is going to need to appoint directors. I'm hoping they're going to be able to appoint 5. So I'm encouraging you and neighbors that aren't here, if you're interested in serving on the board, please let Larry or Bob know. I don't know what the exact procedure is going to be for making them aware, but whether you were a previous director who's recently resigned or whether you're somebody who's never served before, if you're interested in serving, please let them know, because out of the crop of volunteers, they're going to need to select 5 to appoint to the board. And one of the reasons I brought up the DNO gap, and one of the reasons I'm going to work very actively with the board, we have to get that coverage in place. It's kind of strange, but you have a specific exclusion in your DNO policy for any claim related to that 2012 lawsuit in the MSA. What that means in layman terms is if somebody sued a director personally, there's no coverage there should a judgment ever come to them. Now, DNO coverage by its very nature does that. If you're serving on a board, you were trying to do things the right way, but something went wrong, damages were suffered, you got a judgment against you, your DNO policy kicks in and pays that judgment. It's extra protection for directors. You don't have that because of this odd exclusion in your DNO policy, and I think that's in large part what led to concern from a lot of directors of, whoa, do I want to serve if I don't have DNO coverage? Not there. I find it very odd that 5 years later that exclusion's still there. I spoke with an individual today who has an insurance company. They specialize in HOA condo law. I didn't mention your name or any of the names of claimants or lawsuits. We spoke in very general terms. But he too thought that was very strange. Because the reality is anybody can sue anything. I can file a lawsuit against my neighbor tomorrow and they'd have to defend it, even if it had no merit to it. Now there's checks and balances to that. Under 720, you have an entitlement to attorney fees if you're the prevailing party. So if somebody files frivolous lawsuits, if we prevail, they're going to pay not only their attorney fees, but our attorney fees. That is the checks and balances that prevents people from filing frivolous lawsuits under 720. The problem is you still have to defend the lawsuit. And when you have DNO coverage in place, if Chester as an individual gets sued, your DNO company provides an attorney to defend it. With that gap in coverage, you don't have that attorney available to you. Right. So I think a paramount goal is filling that gap and getting DNO coverage in place. Let's not repair any more roofs. Let's not do any more work orders. Let's not amend our documents until we get that gap filled. That's a paramount issue that I'm going to be working on. And then these procedures too, I recommend you do no maintenance other than somebody's, a comet falls through somebody's roof tonight until we get these procedures in place. I do not think it would be wise to continue with your phased maintenance until we iron this out.
The president does not have overriding powers. It's on the majority of the board.
Absolutely. So easily solved. Notice a special meeting in 48 hours and have a majority vote overruled. No single director can control the corporation.